Good morning. It is time for the Thursday morning live stream. Used to call it an update, but I'm not always updating you on stuff. Sometimes we're just talking about some different things. So it's now going to be called the live stream. We're going to do every Thursday morning, still at 10:30 for anywhere from 5 to 15 minutes. And today I'm going to talk a little bit about contracts. Contracts. Everyone needs contracts, and that's probably 80% of the work I do is negotiating contracts or drafting contracts for people, the documents that they need to run their business. And I've said this before in other live streams, but I want to go over it again because I'm in the process of co-authoring a book with a friend of mine. It's going to be about ways to avoid getting sued in your business, and a lot of it focuses on agreements, partnership agreements, contracts with vendors, client agreements. You know, get involved in a small investment deal, you're investing in a local business, you're doing a small real estate deal. And I constantly see things that people do because they think that they have the skills to draft an agreement. Okay. Even people get templates offline and they put agreements together, but they don't know what they're looking at. They don't have the experience to do it like a lot of my colleagues and myself do who do this on a regular basis. So you can watch for the book. If you go to buyinghackerlaw.com, you can subscribe to our email list. I now also have the digital business card. So you see up in the corner of the screen, text law to 21,000 to get my information and to interact with me and follow the podcast. We have a lot of guests coming up about all the business planning stuff that I do and writing agreements. And so be sure to follow that on Apple, Google, Spotify, Stitcher, and all of the social media platforms. So let's talk about contracts. So the real reason, and I'm starting to revisit materials. Last week I talked about things to do to protect your child when they go off to college and they're now of age, and you need HIPAA releases and healthcare directives and things like that. So I've covered this a bit in other updates and other live streams, but today we're going to talk about contracts. So if you're drafting a contract, and I'm not suggesting you should do it yourself, right? So don't practice law, and I said this in other weeks, like we practice medicine in the West, and that is waiting until you have a problem to go to a lawyer to now fix the problem that you created because you didn't go to a lawyer in the first place. Make sure that you use an attorney, okay? But if you don't, or if you're reviewing your agreement to decide whether, hey, maybe I should get a lawyer involved, remember that a contract has two purposes, really, okay? One is the contract lays out what the deal is between you and the other person or the other parties, right? What are the terms? What are the stipulations? What do each person have to do? What are they allowed to do? Okay, that's the first half of it, right? So if you're lending somebody money, it talks about how much money you're lending them. It talks about, what the interest rate is. It talks about if you pay late, all those types of things. And then, which is common in lending documents, there's default provisions, meaning you breach the contract, you miss a payment, you don't make payments. What do you do? Now, outside of the lending area, where you're talking about business contracts, whether it's a contract with your partners or a vendor contract or a client contract or whatever it happens to be, a lot of these contracts that I see that are what I call homegrown, because they were written by the people that are involved in the transaction and there were no attorneys representing the parties, are missing the default provisions. The whole reason you sign a contract is because when things go awry, when things go bad, it's not if, they will. There will be misunderstandings between you and your partner. There will be arguments, disagreements, things that he or she doesn't want to do that you want to do, or vice versa. You have to have provisions in the contract that say, okay, if we disagree, if we misunderstand each other, if one person does something that is outside the terms of the agreement, what do we do? How do we deal with it? Do we try and amicably solve it and then go to mediation? Do we go to arbitration, which is a more formal and sometimes more costly process than mediation? Or do we go to court? And at what point do we go to court? Does one of the parties get attorney's fees if they win or not? If you don't have attorney's fees in writing in a contract, you're not going to get them in a lawsuit. And a lot of the things that you put in a contract is to get people to settle before you go to court, right? I don't go to court. I'm not a litigator, but I am a negotiator. I deal with a lot of situations that are blowing up in litigation to negotiate them to keep them from going to court. That's a significant part of my practice and something I'm very good at. Negotiating something so the parties can kind of get what each one wants, because nobody wins with litigation, right? You might win in court, but you've spent so much effort, probably a lot of money suing each other. You're better off focusing your energy on moving forward with your business, on working on things with your family. Going on a vacation is better than litigating. So I try at all costs to keep people out of litigious situations. And that's what a good contract does, because it puts people in a position where they know what the rules are. They agreed up front what the rules are going to be. And now if they want to separate, or they don't agree, or they don't understand each other, whatever it is, this is how we deal with it. That is constantly missing from contracts that I review. And that is what you get when you deal with a professional like myself or another attorney that's been practicing for more than 25 years, that has dealt with hundreds and hundreds and maybe thousands of situations where I've drafted agreements or reviewed agreements or negotiated agreements in various contexts, whether they're for professionals or consultants or a lease for somebody. I'll give you an example of commercial leases, right? So I review commercial leases on a regular basis, and I'm brought in, maybe I wasn't the guy who was involved at the beginning, where there's a dispute between the landlord and the tenant. And often it's over not necessarily rent, but sometimes common area maintenance charges. They get a bill from the landlord and it says, oh, wait, this year the maintenance is going up by $500 a month, right? Which is $6,000 for the year, which could be pretty significant. There's no provisions in these leases for questioning that, for having a certain time period in which you can say, okay, wait a second, we have to true this up, meaning I want to see the bills. I want to see where the $6,000 come from. And I have a right to say whether it's correct or not. And then what happens if, and I've had this situation where a landlord forgets to even tell the tenant about increases and then sends them a bill after 10 years and said, you know what, we forgot to bill you for the last 10 years. Can you write us a check for $60,000? And of course the business owner says, no, I don't have $60,000 laying around. I can just write you a check. And you don't even know if it's correct. So there should be provisions in there that allow for the questioning of the bill, how much time you have to question it, what their response is, and what if they forget to tell you for several years. They should lose the right to give you the bill, no surprise bills. Also, what's the difference between a capital improvement on a lease versus maintenance? If they have to replace the driveway or the roof or the windows in the building, should that fall on the tenants? Now, landlords would like it to fall on the tenants, but it's improving the property that the landlord owns. So if I'm representing the tenant, I'm saying, no, that's on the landlord, because he gains a benefit from doing that. He doesn't charge the tenants for that. So those kind of things are not addressed in contracts because it's not something that you do on a regular basis. And I've worked with even lawyers who now don't practice, and they're investing in small real estate deals or investing in businesses, and they kind of put together a contract, but it's always missing the provisions that I need to deal with the situation when the restaurant they invested in is no longer paying them, is having financial troubles, isn't paying. And having a bunch of text messages and emails is not going to get you there. So that's what I wanted to talk about today. Contracts. If you have an agreement, you better make sure that all the proper legal stuff is in the agreement. And there's things that you're not going to be able to figure out on your own. You have to go to a lawyer. Even where you choose what law is applied and what jurisdiction you can bring a lawsuit in if somebody's out of state. Very difficult to deal with people if you're investing in things out of state, because you may have to sue them in the state that they're in, and that state has laws you don't know about. So that's my piece for today. Again, I am Mitch Beinhacker. I'm a business attorney in Clark, New Jersey. And you can find me on Facebook, LinkedIn, Instagram, Twitter. We have some things on Pinterest, although they don't post too often. You can follow the podcast, The Accidental Entrepreneur. Always looking for interesting guests. If you have any recommendations or you'd like to be a guest, please contact me. And also support our sponsors, which you can find on any of our emails. That's Royalty, Digital Accelerant, the digital business card, which is what you're texting law to 21,000. That's the digital business card. And Fetch Internet, the app that connects you to the internet inexpensively and securely. So I thank you for listening today, and we'll live stream next Thursday. Have a good day.